after a hearing that lasted several hours. The Supreme Court has reserved judgment till March 3 in the suit filed by some APC states seeking to allow both the old Naira notes and the new Naira notes to coexist as legal tender. Well, the court rejected all moves by counsel to the parties to further delay the case. Arise Judiciary editor Tobi filed this report.
It's a parade of some of Nigeria's brightest legal minds. As brilliant as they are, the Supreme Court, determined to hear all arguments for and against the continued use of the old Naira notes, does not have the luxury of time to allow each of the lawyers expatiate on their submissions. But out of respect for Mr. Kanu Agabi, the counsel to the Attorney General of the Federation, who was also the most senior lawyer present, the court allowed him some time to shed more light on his written address. He insisted the Supreme Court does not have the jurisdiction to hear the case and that the plaintiffs were crying in the wrong court. He says they should have taken their case to the Federal High Court. In the course of the proceedings, the presiding justice, John Inyangokoro, asked the question who addressed the nation to very our order. He also resisted vehemently all efforts by some of the lawyers to get the case further adjourned. He said the parties want to make the Supreme Court the scapegoat and that the court would resist such attempts. The court also seized the moment to call for further amendments to the 1999 Constitution to make sure that not all cases end up at the Supreme Court, adding that the caseload of the court is too high. Before the case was adjourned for judgment, counsel to the aggrieved states asked the court to grant all their reliefs. On the other hand, the federal government, Edo and Bayelsa states asked the court to dismiss the case for lack of jurisdiction. On whether the court's earlier order that both the old and the new Naira notes should remain legal tender still subsists, the Supreme Court refused to make any statement on the matter. The lawyers at the court hearing later addressed journalists.
We are all working at trying to salvage a difficult situation. That's where we are. The Supreme Court is trying to do that. The President is trying to do that. It's one nation, one people. We are looking for solutions.
The President has the power, further to Section 23, to direct the CBN governor. But the time frame given for this policy to be implemented and the terms are very short, and it's not convenient for the plaintiffs and indeed Nigerians to conform.
The government is apprehensive that if this policy is not reversed urgently and speedily, we might witness another serious outbreak of violence in Lagos.
Our Judiciary editor Tobi joins us now live. Tobi, good to see you and thanks for your time. That was some grueling moment in the court, several hours, and Nigerians are wondering at the end of the day, it's till March 3.
Yeah, that's correct, but I'm not sure there is anything the court could have done because they have to sacrifice hours, their own time to make sure that this case is heard and decided as quickly as possible. There are cases that are still 2018, 2019, so in the Nigerian sense, this is pretty fast, and I think the justice deserves some commendation.
Absolutely, and the Supreme Court really seems to be in a hurry to get this done with very quickly. But it did not fail to make a point that it does not want to be a scapegoat in the case between the federal government and the state governors. The Supreme Court is, right when it, puts that case forward. But what are the major issues that came out of this today?
Well, I must tell you that it was quite an interesting day at the court because the plaintiff hired some of the best lawyers you can get in the country, and all of them came prepared. It's quite very interesting. Some of the arguments they raised are some that we have never even heard of. That is due to the brilliance of some of these. They went into research, came out with different arguments to the case, and even I'm sure the Supreme Court was surprised. So, but beyond the fighting and the argument outside, the lawyers are always comrades. So, justices, the plaintiff lawyer, the defendant lawyers continue to exhibit that friendship that the bar is known for.
What do you make of the case, very quickly, when the Zamfara, through their lawyer, Mr. Abiodun Owunikoko, asked the Supreme Court to actually set aside the broadcast of President Muhammadu Buhari on February 16?
Yeah, well, obviously the Owunikoko SAN raised that argument, but the courts maturely said, look, we'll look at it, but they refused to be pushed into taking any immediate action. There are other people that, like the Lagos State Attorney General, he asked the court not to even hear the federal government because they are in contempt of the earlier order. But the court, that is when the issue came up that, look, I mean, both state and the federal government want to, use the Supreme Court as the scapegoat, and that we refuse to be the scapegoat. That we are going to give opportunity to everybody to express his case, and then we are going to give a final judgment. Whether the party obey it or not is not our business. Our business is to deliver a final judgment, and that is what they have agreed to do.
On March 3.
Yeah.
Well, I'd like to thank you for your time, Tobi Soniyi.
Thank you
very much.
Yeah.